Okay, good morning everyone and welcome to our Wednesday morning online seminar. Today we are looking at project security and construction contracts, and this is being led by Mohammed Haque, who is consultant, barrister, adjudicator and quantum expert at Fletcher Day. As always, if you wish to ask Mo a question, you'll see on the screen there his email details. You can either ask a question during the session by using the Q&A or the chat tool in the bottom toolbar there, and he'll endeavour to answer as many of these as possible at the end of the presentation. But if there's something you don't wish to ask in an open forum, please feel free to email Mohammed directly, mohammed.haque@fletcherday.co.uk. He will always be happy to answer any direct queries from you. Okay, Mohammed, I will hand over to you and we can get going.
Thanks, Julie, and welcome everyone who's listening or watching this morning session, which is a bit complex one, I would say, but very, very important because if we are involved in a construction project and its contracts, the liability of the party may continue, and the reason beyond the construction, it may start before and it may continue beyond the project construction time, and there are issues which may crop up years after the project's construction phase is over. This is because a construction project is regarding building any space, either a residential or a commercial building, or an infrastructural facility such as roads, tunnels, bridges, and all various types of civil construction, and it has a life cycle of years and years, 20, 50, 100 years life cycle. So the owner of the built space wants the project from the very outset to secure the interest of various parties and the building or the built space itself. So keep in your mind that people need security regarding a construction project or a construction of a building or a civil structure right from the outset, and by that I mean that the project is executed as desired and executed safely and constructed without having the risk of let's say things like theft or damages through fire or arson or similar things during the period of the contract. And then of course the project then is handed over to the client, and more often than not the client or the employer sells or lets the project out or allow others to use the space. And the question of the built space be a safe and secure place for the future people who are using it is also come as part of the project security, because that you need to construct it legally correctly and in a safe manner, and securing the site so that the materials and the plants are not lost, and the people who are building are do not get into situations where they they have personal injury or even fatal accidents. Of course, that's one part. And then the design of the building, whoever professionals have done it, needs to be appropriate, complying law, and and producing the best output. And of course, if all these different people are looking for security, then we need to know, what's done and how is that handled. And one person's security may mean an obligation for another. So in this presentation, I will discuss the different interests and the securities parties look for and how they're ensured. So we go to the next slide. This is who needs the security and protection. Of course, it's any construction project is the employer's project, or sometimes we call them the clients. They want it for one reason or the other. They decide to construct something on a piece of land or on top of a building or underneath of it, the subsurface projects. And what they do, they want their money to be spent to achieve the project as they understand it or define it in their briefs. And then they also want security against pilferage or loss of any kind, or they don't want to become liable because they hand over the possession to the contractors and others, and also to other employees. And then, of course, once the project is completed, they get it back. They want a defect-free completed project, and also they want to secure the use of it in a manner that the users are safe from any hazard. So, and sometimes that may be a statutory duty or a common law duty to maintain. So that's that. And then, of course, whenever you are building something, you run the risk of coming across other constructed assets which exist from the past. You see, like if you're doing a tunnel or even a house, you see, you come across the services who are connected to that piece of land, or tunnels which goes underneath, pipelines which goes underneath, and drains which goes through it. So these are pre-existing assets, and right from the planning stage, others will intervene to ensure that their assets are not interfered with. So they kind of need security as well. Now, at the construction phase, of course, the site itself needs security. Sometimes what happens that the sites are not fenced, or couldn't have been so, because it could be like you are doing a small drain by the side of a busy road. The busiest one I've ever come across was at a town center, and which is a very common thing. Not only once, I've done that many a times at a town center, doing a road refurbishment on the main kind of section. So that's something where you can't, even if you want to, stop or put a fence around and stop everyone, So the site requires security in terms of the materials, the plants, the other, the users, men and people, of the site. They all need security at the construction phase. Of course, the neighbors come in mind as well, because they any construction would have some hazards, and it could be a noise pollution, it could be other types of problems of, let's say, oscillation, which creates problem to the neighboring buildings, and so on and so forth. And if it's a residential one, we know that the party wall things is a very popular thing in this country. If the two neighbors are very near from one to the other, within a particular distance parameter, then you need to take special care. And of course, certain things are there nowadays, digital surveys for checking that you are not disturbing when you are doing, let's say, a foundation underpinning or fresh foundation to your building. You are not disturbing the neighbor's built space. Of course, in modern time, many a times the funders come into play. They fund the construction first, and then through a bridge loan, and then they transfer that to the buyers or the tenants of the project or the employer later on. So funders do get involved right from the beginning, and of course, since they pay the majority or inject the fund, or the majority chunk of the fund, they like to have security as well. And I've already mentioned the personnel who are working there, visitors, the plants and the tools and the materials. Now, all of these need to be secured, and we need to have a system in place that the security is given to all of these. And then, of course, in the post-construction phase, I've repeatedly stated that the buyers, if there is one, or the users and other occupiers, of course, you don't expect a building to be a haunted one once, or a built space to be a haunted one. It will be in use, and someone or even in a remote construction project, let's say a underground sewage treatment plant would also be used in the sense that for its operation, some people will go in there. So all these people need security as well, so that it is safe and secured to use it for its intended purpose. So these are the people in general, or stakeholders or interested parties, who want the project to be secured, so that it's safe, so that it's built properly as per the brief, and complying the law, and taking into consideration the risks, which is a very common word in construction world, that it poses at the time of construction and later on. So we will get to the next stage. Now, how can you provide security to people or to the interested stakeholders and all? Of course, insurance is one tool, and keeping in mind the risks that a newly constructed built space create. Government in this country intervened, and they've facilitated a particular type of insurance, which is mostly used for new builds and for ages. And I've just mentioned NHBC because most of us know that, but that may not necessarily be the only option available. But it's the oldest and most prestigious, and for various reasons, I always felt it's safe. It's a bit more expensive than the other options available in the market, but it's if you are building something, I think the employer would be better advised to take an NHBC insurance, which, as it works, makes the contractor liable for the construction phase, and then a particular period of 3 years normally, and then for coming 7 years, they take the responsibility, meaning the NHBC or other security providers or insurance providers take the responsibility to ensure that if anything goes wrong, if any defect is exposed or found, the NHBC will promptly come in and through their existing repair and maintenance practices, they will do the remedial work and take the defect off. So that's one kind of option the employers have, and as well as to secure the site at the construction time, the employers also can take different types of insurance which is available. Now, the alternative is there are many risks which still exist, and possibly you cannot expect all of them for insurance for all of them. So what happens? The employers and other parties, they try to make an interested party or a party who's working responsible. For example, the responsibility of the design team, that's not something which NHBC is concerned about or any other similar type. Similarly, not the contractor, because unless the design responsibility lies with him, traditionally in England, it doesn't lie. And even if design liability lies with him, that's partial. The contractor's responsibility is not turnkey in this country because you cannot let a scheme out till it reaches a point. So the employer, in one way or the other, is responsible for the design or remain responsible for the design. And of course, employers do not like it, so they kind of shift the liability or transfer the risks. And that's what also happens, that one party start transferring the risk to another, and make them liable. And on certain matters, as I said, insurance is available so that the party who's responsible for the risk can secure its position if anything goes wrong. There are other occasions where you can't do anything and you have to take the risk, and then and may have to give an undertaking, an indemnity, a bond on whatnot, and the guarantee. And the guarantee could be a personal, a corporate, or a guarantee bought to support your performance from a financial institution. So a wide range of possibilities and alternatives are available at the hand of the employer and the other interested parties, and we'll explore them one by one. Okay, how the game runs, you see. Well, I mean, I expect that everyone attending knows how a construction project works, but just will give a brief reminder. What happens? The employer or the client first conceive or conceptualize or start thinking or dreaming sometimes even to build something on a piece of land, either underground or overground, whatever it may be. And as I said, it necessarily doesn't mean that it's going to be a house. It could be anything. It could be a drain, it could be a tunnel, it could be a tower, it could be a bridge, it could be a road, it could be a jetty, it could be a station, all sorts of things. And then, of course, residential and commercial buildings, such as houses, hotels, and so on and so forth. So someone who's got the right to build on a piece of land will first conceive or dream or wish a construction to be carried out and a space to be built on a piece of land, of course. And he or she will employ an architect or other designers, sometimes we call them the employer's professional team, to convert the brief or the thoughts to a construction project. a conceivable and concept which is translated into various plans, designs, and constraints and all these. And of course, there is planning authority who will look into it as well. And as and when you reach the proper stage, the scheme will be let to the contractors to build. That's the normal practice. Sometimes if it's a design build, the contractor comes on board early and give their inputs into the contract, but primarily it cannot be actually tendered till you reach a particular stage of the design process. And obviously the first team or the first group of people the employer come across are the professionals, as I've said, who conceptualize the brief and then develop the brief into a workable plan. And there are different stages, 1, 0, 1, 2, 3, 4, just like the A, B, C, D, whatever way you want to mention it. RIBA has staged a phase of that, and tender phase and onwards will be the construction phase. But obviously any employer, a prudent employer, would like to see that things are done properly at that stage. And what can they do? You know, they cannot take insurance to ensure that the professionals who are working properly. So what can they do? They can ask or seek appropriate indemnity or bond or guarantee from the professionals. And of course, they will quite often ask for a warranty in the form of PI. That's quite normal, you know. Alternatively, it could be left to a clause, an express clause of the construction contract, which defines the responsibility of the service provider, if it's later on of the contractor, and the extent of the liability. The normal extent of the liability of the design professionals are, of course, they cannot be negligent. It's not a strict liability as long as they perform what a reasonable professional would have performed. A reasonable professional of his standing, having the knowledge, would have done or wouldn't have done in a particular circumstance is the test by which, or standard by which they will be judged whether they have gone wrong or right in designing the project and making it happen. And of course, the contract, and this is the concept, just as I mentioned, is not a concept of contract law, it's a concept of tort. However, let's not complicate that. It has been borrowed, that concept has been borrowed and it has been inserted into the contract. And of course, the question comes how long you can keep them responsible if you put it into the contract as a clause that you're responsible for this, that, the other. Of course, it depends on how yourself, you can put any period expressly within the contract. But if you haven't provided, then of course there's something called a limitation period. So the limitation period will run for 6 years for the breaches, and as and when it becomes apparent. And then if it's a normal contract, if the contract is signed as a deed, it will run for 12 years. And don't forget that the PI or the indemnity insurance could be actually could add the tortious liabilities to others as well. And then, of course, whenever a defect and a problem arises, the time will count from then. So it's quite a kind of lengthy period of time in which you may, if you are a professional and provided a security for the project, for your job, meaning that for the designs you have produced, you run the risk of becoming responsible if anything goes wrong for years and years. So it's a very, very good teeth as well, and a serious thing for the professional to take into consideration. Don't take your job easily, because one particular claim may ruin your whole career. And I've come across architects in particular, many in number, and sometimes when quantity surveyors, one or two easy thing, they have taken it easy at the time they are performing, and then came in, and it followed by a case, and then their entire credibility was at risk. So it's a very, very serious thing for, if you are a professional, to keep in your mind. And of course, if you're an employer, it depends on the level of security you want. But I would always say that do not only go for a personal guarantee or a personal undertaking. You should always consider having an appropriate PI, and secure it for yourself through the contract or for the prospective users. Now, limitation of using the contract mode is that a right in the contract can only be enforced, that's the general condition, there are a few exceptions, by privy to the contract. So in other words, to make things simple, for example, an employer employed or appointed an architect, and the architect was negligent in providing the design. Now, even though the contract would say that you would remain responsible for or to the contractor, in reality, the contractor cannot sue the architect, because it's an age-old principle of English law that you can only hold a party to a contract responsible if you are a party as well. And more often than not, when the professional contract is going to be signed, there won't be any contractor or a specialized subcontractor in existence at all. The same applies for the contractor and the subcontractor. If the subcontractor does something wrong, and of course the employer has the benefit of going to the contractor. However, if the contractor goes burst, it doesn't exist, he leave after Brexit, he left the country. So where would the employer go? You know, there's no one he can make responsible. So that's the limitation. You can write down anything in your contract, but the problem is you won't be able to enforce it. Now, the alternative, of course, is in the contract, you can say that you have to provide a collateral guarantee, a warranty, or an insurance supported thing, or a third party financial institution's bond to secure your response, to make sure that the person who did the wrong will become responsible, and supported by it. And those documents are deeds, and they can be used by any beneficiaries if they are mentioned within the documents. So regardless, although I would still say try to bring in as many parties as possible, but they, regardless of the privity of the matter, the party who suffers something may enforce a right in a bond or a guarantee. Also, keep in your mind that as I said, bring as many parties as possible, and if you sign the contract as a deed, and then if you assign or a particular part of it, a responsibility of that, into someone else's hand. For example, you let the project to be constructed by the contractor, you can, within the bond, if you sign the contract as a deed, and the contract say that you'll be assigning the benefit to a third party. And if it's a deed, then even though the contract itself is a deed, then even though it's not been the ultimate beneficiary of the security is even if not not a party, if the rights transferred through Law of Property Act, that person may be able to get hold of the person who's actually originally responsible to the other party. So primarily two things, remember this. One is the contract clauses, of course, which you can enforce and be enforced by the parties to the particular contract you're talking about. The contract will be, I'll be showing you in a flow chart how many different contracts are possible, but only the parties. And then the collateral warranty, bond, guarantee, through which other party may come on the shoes and then enforce it if they are mentioned as such. Here is the flow chart which describes the possibility of contract, where the core, of course, the starting point is the employer. An employer will have contracts with designer 1, designer 2, meaning the architects, the structural people, the electricals and mechanicals, and other types of services, all sorts of from the center of the earth to heaven, whatever things are needed to be done to complete the project construction needs to be designed. And by design, I simply mean a set of plan and instructions for carrying out the activities. For those of you who are not a QS, I will explore or explain this thing a little bit more. What I mean by this is the QSs historically in this country has divided a construction into a list of activities. Okay, so in other words, if you are building, let's say, a building, you need to go on and check the soil, cut the soil down to the appropriate level, put the foundations, and then the structure of the building. And of course, every level from the subsurface to the rooftop, and then inside decorations and outside decorations, and the first and the second fix of the electricals and mechanicals will all be sort of charted into a list of activities under the new rule of measurement, or SESM, or highway and transport bill, whatever it is. And then you got to plan them, you got to plan all of them, whoever it is, be it the employer, be it the contractor, be it someone else, they have to appoint somebody specialized in that particular design trade, a professional, to plan it first and get approval, and then also make a plan of health and safety, which is a recent mandatory requirement of statutes. So because there are different types of designers. Now, mostly and traditionally, the employers will employ them. And if it's a design and build contract, then after sort of it reaches a certain level, the contractor may come in to make the design into a workable condition and then build it. So two options: the designers could be directly employed by the employer, the designers could be employed by the contractor. I believe there should have been an arrow from here to the contractor's point to the designers 1 and 2. But anyway, nevertheless, that's that. And then, of course, employers, quite often than not, unless the contractor has loads of funds and that he comes on board and shares the funding responsibility of the construction, the employers, unless they're very rich, they will go to funders to fund their projects. And I mean, the going rate is the funders put up to 80% of the built space value, market value of the built space, for construction. So the 20% needs to come from the pocket of the employer. So they have an axe to grind in a real sense to see that until they get their money back, everyone is doing things properly, and their position is secured in case anything goes wrong. And the middleman with them, like the employer, they have the contract to go to them directly. So very often they will impose a clause with the employer, a clause that as and when you let it out to a contractor to construct it, we want them to give us a guarantee. So there is a relationship goes between the employer and the funder, and between the funder and the contractor. And to be honest, they take the advantage of the of making the design team responsible as well. So they want security from them as well. And as I said, it could either be a contract type personal guarantee, or it could be, and more often than not, it will be a third party bond from a financial institution, so that if anything goes wrong, they can take the advantage of it. Employer will have contracts for the construction phase with a contract administrator, employer's agent, or an architect who will kind of oversee the project management on behalf of the employer. The same applies for NEC contracts. That we have got two officers in particular. One is project manager, who's got the management responsibility, somewhat similar to CA. And in JCT, the contract administrator's responsibility to oversee the quality is there, but it's not so prominent. But in NEC, we have the office of the project supervisor, who's solely responsible to look after the quality aspect of the construction. So it's equally possible that the employer would like to have a guarantee of some sort, and PI if possible, from the project manager, supervisor, contract administrator, or the employer's agent and the architect. Same goes for QS. If they do a wrong valuation, it could be a disaster. They might overpay. And for example, if the project contract says that QS will only release payment, and sometimes these are third-party people because the funder is another third party. So the QS is a professional firm. So what they do, they don't know the quality of the job at all. They are the quantity surveyors. QS doesn't mean quality surveyors. So it is for the employer. It's something in JCT contracts frequently missed by the employers, to employ a building surveyor of some sort, and to assist the CA or the EA to ensure that when they're taking the job back, they go through appropriate tests, and they ensure that the contract clauses have been followed. And that's something the project supervisor in NEC supposed to do, so that if something is not built as per the plan, the matter is straightway pointed out or identified at the point of taking it back. And the project team for working for the employer would say, look, we're not going to take it back because you haven't done it properly. Now, more often than not, in situations like these, the QS is saying, okay, you will release payment you'll be working in close contact with the CA and others, I mean the employer's QS, and you will release payment or authorize payment to this funder if sometimes, which is called drawdown between the employer and the funder, that the employer just allows the QS to authorize, and then the funder pays the money based on an invoice from the contractor. Now, if the QS is responsible to ensure that a full certificate is issued, clean one, by the CA or the EA or the surveyors acting under them, only then he releases or authorizes and says that, okay, I've checked the quantity and this is it, you can now pay for this much. And then if he certifies an amount without following the procedure as stipulated, it could be that he's treated as negligent and will be responsible. Now, the contractors, normally they do very least if they're told to, or they don't do anything. They just manage the project and let it to the subcontractors of different types, who of course then let it to the trade operatives. So it goes on and on. So the contractor would normally, if you are reviewing a contract between the contractor and subcontractor, the first thing you keep in your mind is the risks and the securities provided by the contractor is then given or shifted to the subcontractor. And occasionally, again, the funders and the employers, they want a direct kind of guarantee or a bond. Finally, the employer, once the thing is built, he will transfer it to the purchaser, so you'll be or a tenant and other occupiers. And of course, they would like to, they're investing considerable amount of money in buying an asset or a property. So they would like to see that it's a secured building or a built space. And of course, they would like the advantage, because the employers will go away from the project at that stage, the advantage of the securities already provided to the employer to be used by them if anything goes wrong. And as I said, it's this NHBC type security and insurance they provide for things like this. Other contracts, if not, then you'll have to ensure to keep the designer, the contractor, the subcontractors equally liable to the first buyer through a collateral guarantee or a warranty specially designed for them. And if the contract between the employer and the contractor is signed as a deed, in that case, this privilege may transfer under the Law of Property Act. So that's another advantage of signing a contract for the employer with the contractor as a deed. Now, what a contract can do, I've already stated somehow, but just to recap, that it can only make another party responsible. It can cause a party to arrange an appropriate, sorry, I missed this article, to arrange an appropriate security in favor of course, and make it available in favor of parties who are not a party to the contract. So in other words, what I'm trying to say here is, if the employer wants the design team to be responsible, he may ask for a PI, and then he may extend that PI through the contract between the professional and the employer to the contractor and other intended users. The same applies for the contractor and vice versa. Again, some examples. What happens, I will take an example of JCT, design and build contract. Of course, and I'm talking about the design responsibility because it's the most common thing that occurs in construction world. This is, of course, a new variant. It was not there earlier, but earlier forms, or those which are not a design and build form, also has, in most forms, be it a standard building contract or intermediate, has the option for the employer to ask the contractor to design certain part, if not full. Okay, so it's not something wholly new, but in design build, every design responsibility from the time of the contract, it shifts to the contractor. Now, so the contractor becomes obliged for the design if anything goes wrong. What standard do they need to follow? They need to follow the standard of an architect. Of course, reasonable architect acting, or a reasonable other professional acting into their own profession. So the responsibility goes on their shoulder. So what they can do, what they need to do, as and when they're employing a design professional, be it an architect or a structural engineer or a utility or service design provider, or a building regulation compliance professional. I mean, so there are so many electrical and mechanical service providers. They need to secure their own position. They need to shift this liability which comes on their shoulder. Now, design and build contract and other contracts, wherever there is a contractor's design portion, JCT suit, has done a very good thing. In an earlier case law, it was decided that the contractor comes into be responsible for the employer's requirements, which are given to him by the employer. And if it is not good enough, then he being a specialized contractor will become responsible. But JCT clearly states in its model form unamended that contractor is under no responsibility to check the appropriateness of the employer's requirement. But that's limited to, first of all, even if not amended, because most frequently this is amended and make the contractor responsible for it. So although the clause exists, in most cases, as I have experienced, the lawyers suggest the employer to change it and make the contractor responsible. Even if that's not the case, if it's not the case, what happens? The responsibility, although doesn't exist at the time of signing the contract, as and when the contractor gets into the phase of building a particular a part or an activity or an operation of the whole job, for which he has a design responsibility, the contractor needs to check the design, and if he finds any divergence, discrepancy, or any problem, he comes under a responsibility to inform the CA or the architect. And the good thing is he gets, if that's accepted by the architect or the CA, then he gets it as a change and a variation, and he gets the value recovered for correcting it. So that's something a plus for the contractor, but it's not absolving him of responsibility at all. It is just allowing him to charge extra. So they still needs to be cautious for their design, but up to the level of a design professional, not an unlimited liability or strict liability, which is the normal case in a contract breach. So if you are in breach of a contract, for example, if specification says that a particular code needs to be complied with for a particular type of goods, in that case, you have supplied to build the building. In that case, regardless of whether it's causing any loss or not, you are in breach, and the contractor in certain cases will have, the employer in certain cases will have even the right to terminate the contract. So it's not as strict as that, but the consequences may be disastrous. So you be careful. I mean, the contractors, you be careful. And in any case, do shift your responsibility, seek PI or bonds and guarantees when you are employing professionals, and that's it. Now, that's if there is a breach. You might have disappeared from the scene, but then if there exists a PI or a bond or a guarantee, you have facilitated and extended the bond to other parties. One of the other parties will come into place on shoes of yours and will take advantage of that bond or the guarantee. Now, if there isn't a breach, now you might say, okay, how can there be a problem and no breach? A very, very common thing. And I'll finish by giving that example here. The subsurface condition of any building. Now, or the site conditions of a project where you are refurbishing, you are the contractor or you are the employer, you are refurbishing an existing building. Now, the site risk under the JCT suit actually is on the shoulder of the contractor if nothing is said. So unlike the Moorcock case, or the common sense sometimes dictates that you're giving me a site if there is something which is not described into the site information or ground condition report or anything. You're the one, the employer, is the one who should bear the risk of the site. But the reality is, in construction contracts, the case laws and all the model contracts do the same, more or less, that site risks are either expressly or impliedly on the shoulder of the contractor. Now, even sometimes you provide ground condition reports for subsurface work on a site, and then you add a caveat into the contract. You means the employer. Add a caveat into the contract that you're a specialized contractor and it's your responsibility to satisfy yourself that the site is workable, and anything underneath, doesn't matter what that is your responsibility. Now, on one hand, you have the the choice of saying, no, it's too much of a risk, I'll not take it. You, the contractor, might say so. On the other hand, you'll not get any job if you say so. So you might think, okay, I'll go blind and I'll take that responsibility. And once you open the site, you see that there's a huge chunk of concrete underneath, so you can't actually, or even a drain or other facilities and assets of an utility company which you cannot touch, and it's not possible to work on that the way you have planned it, or the design has been given. No one is in breach. And what can you do? There isn't any insurance either. So where's the solution? No solution whatsoever. Only one solution: before you take the contract or put this contract or sign the contract, know your risks. That's the only thing you can do. So if you think, okay, I will walk into my grave and dig it myself, that's your choice. But be aware that where you are entering. That's all from me today. And it comes to an end. Hand over to Julie.
Thank you very much, Mohammed. Thank you. That was an interesting walk through project security there. It looks like everyone's questions have been answered, so well done you. But if anyone does have a question, please feel free to ask now via chat or Q&A, or as we said earlier, if there's something you don't want to ask in an open forum, you can email Mohammed directly, mohammed.haque@fletcherday.co.uk. Okay, we are back with Mohammed this evening for the programming on time with NEC and JCT. And if you would like a place on that, you can email us on seminars@fletcherday.co.uk and we'll send you the login details. Other than that, we are next back with Mohammed. Next week, we have Leave Site Now and Don't Come Back. But we also have in October the latest in his changes in construction contracts, valuation and other implications. So we've got lots coming up from Mohammed there, all around construction contracts, changes and valuation of those changes. So without any further ado, thank you very much, Mohammed, as usual, for your time. Thank you everyone for attending. I hope everyone has a great day. It looks like the weather's going to be fabulous. So please all enjoy and stay safe. We'll see you all again soon.